thanks to Lee Strang, to Dean Barros, the University of Toledo College of Law, and the Federal Society for inviting me and giving me the honor of delivering this year's Stranahan lecture. And I'm especially pleased to be here to talk about the 14th Amendment. An amendment, as I was talking with Lee and the Dean just prior to beginning my remarks, and I was remembering what an extraordinary role that Ohio has played in the establishment and creation of the 14th Amendment, including a very important gentleman by the name of John Bingham, who drafted Section 1 of the 14th Amendment. He's going to play a role in my coming remarks. But you represent very well as a state in terms of the construction of our constitutional liberties. On July 21st of this year, we will celebrate the 150th anniversary of the 14th edition to our national Constitution. And over the decades, its provisions have been the basis for some of the most important judicial opinions involving individual liberty ever handed down by the Supreme Court, from freedom of speech and religious exercise to the rights of due process and equal protection. The provisions of the 14th Amendment are woven into the fabric of our understanding of American liberty. It protects us from the unconstitutional actions of state officials. And given that most of our daily action with the government involves state government officials, it's hard to imagine constitutional liberty without the 14th Amendment. In fact, from a distance of 150 years, it seems inevitable that this country would have added just this kind of an amendment in the aftermath of the Civil War. The Union had just defeated the Confederacy and its ultra-states' rights defense of slavery and secession. And it makes sense that the same men who prevailed on the battlefield would constitutionalize their victory through the adoption of an amendment that demanded that states respect the fundamental rights of American citizenship. But when we look closely at what actually happened, it turns out that there was nothing at all inevitable about the 14th Amendment. It was a proposal born of desperation. Its ratification almost triggered a second Civil War. Ratification itself was almost abandoned midway through the process, and it would take a breakdown of constitutional government and an impeachment of a president of the United States before its ratification would be secure. In fact, the story of the 14th Amendment is one of the most dramatic events in our constitutional history, second only to the Civil War itself. And it's a story that I believe deserves at least an abbreviated retelling on this, its 150th anniversary. It's a story in 3 acts. Act 1 involves the drafting of the amendment. Act 2 involves the debates over its ratification. And Act 3 involves the final round of voting in the states and how securing ratification required an act of its subordination by a very famous Army general and the impeachment of a very obstructionist president of the United States. But first, Act 1. The story of the 14th actually begins with the beginning of the 13th Amendment. So please, turn in your books to page 531 of the Congressional Globe, 38th Congress, 2nd Session. This is the page that records the events in the House of Representatives on January 31st, 1865, the day when the House voted to pass the 13th Amendment abolishing slavery and sending it to the states for ratification. As the Globe reports, and it is there on the internet if you care to look it up, as the Globe reports, the galleries of the House of Representatives were packed that day with men and women, both black and white, including the son of Frederick Douglass. There was enormous public interest in this event. The House had tried and failed to pass the 13th Amendment only a few months before. Since then, however, Republicans had prevailed in the fall elections, and a growing number of congressmen had begun to reconsider whether or not slavery was in fact an indelible component of the original Constitution. Still, no one in the galleries that day knew what the outcome of the vote was going to be before it was actually taken. So here is the event, as recorded on page 531 of the Congressional Globe, beginning with an unusual request by the Speaker of the House, Schuyler Colfax. The Speaker directed the clerk taking the vote to call his name as a member of the House. The clerk called the name Schuyler Colfax, and Mr. Colfax voted aye. This incident was greeted with renewed applause. The Speaker then declared, the constitutional majority of 2/3 having voted in the affirmative, the joint resolution is passed. And that announcement was received by the House and the spectators with an outburst of enthusiasm. The members on the Republican side of the House instantly sprung to their feet and, regardless of parliamentary rules, applauded with cheers and clapping of hands. The example was followed by the male spectators in the galleries, which were crowded to excess, who waved their hats and cheered long and loud, while the ladies, hundreds of whom were present, rose in their seats and waved their handkerchiefs, participating in and adding to the general excitement and intense interest of the scene. This lasted for several minutes. There's nothing like this recorded anywhere else in the congressional globe. It was an intensely emotional and public event, and it had seemed utterly impossible only 3 years before. As Lincoln later commented, it was an unexpected achievement, both fundamental and astounding. It turned out, however, that this vote on the 13th Amendment was just the opening salvo in what was going to become a constitutional revolution. In fact, the 13th Amendment created an enormous problem. Under the original Constitution, slaves counted as 3/5 of a person in terms of congressional representation. This gave slave states a bonus in the House and in the Electoral College. When the 13th Amendment abolished slavery, these millions of newly freed persons would now count as a full 5/5 of a person for the purposes of Southern state representation. So, once the war ended and the Southern representatives returned to Congress, they would do so in greater numbers with greater political power than they had held before the war. In other words, the South's defeat on the battlefield might well result in the South's victory in Congress. Victory for the same political class that had betrayed the country and caused the death of more than 500,000 Americans. For a time, this seemed to be exactly what was going to happen. Soon after the submission of the 13th Amendment to the states, the war ended, Lincoln was assassinated, and the new president, Andrew Johnson, immediately went to work securing the ratification of the 13th Amendment. Johnson quickly established provisional governments in the South and promised readmission to the former rebel states if only they would ratify the Abolition Amendment. The Southern states accepted the offer. They ratified the amendment, and that fall, they sent their representatives to Washington for the opening day of the 39th Congress. And when these former rebels showed up at the door of Congress that day, Northern Republicans were faced with a choice. They could readmit the rebel states and give up on constitutional Reconstruction, or they could somehow prevent the Southern representatives from taking their seats. And that leads to the second most dramatic page in the congressional globe, page 3 of the first session of the 39th Congress. On December 4th, 1865, the opening day of that Congress, the clerk of the House called the roll. The Southern representatives waited for their names to be called so they could take their seats. Their names were never called. The Democrats demanded to know why. The clerk refused to answer. Instead, the Southern representatives were left literally standing at the door as Republicans went about their business. The rump Congress of the North had decided the South could not be readmitted until Congress first solved the problem of the 13th Amendment. President Johnson and the Democrats were outraged. They declared the exclusion of the Southern states unconstitutional. The Republicans ignored them, and they got to work. The Joint Committee on Reconstruction produced multiple proposed constitutional amendments, some dealing with Southern representation, others dealing with the rights of freedmen, others dealing with the rebel debt and the disfranchisement of rebel leaders. In the end, Congress gathered together all of these separate proposals and created a 5-sectioned constitutional amendment. The core of this amendment, Section 2, demanded that Southern states give black men the right to vote or face reduced representation in Congress. This is the paragraph that solved the problem of the 13th Amendment. It was the most discussed and the most important provision in the proposed amendment. And this was the paragraph that had to be ratified before the Southern states could be readmitted. As Act 1 comes to a close, this 5-part amendment was passed by Congress and then sent to President Johnson for transmission to the states for ratification. President Johnson complied, but with a message indicating that he did not support this proposed 14th Amendment. And in fact, Johnson would then travel the country, encouraging the states to reject the proposed 14th Amendment, and his efforts would almost trigger a second civil war. Act II. The 14th Amendment went to the states for ratification in the summer of 1866. Politicians running for congressional office that fall quickly made the proposed amendment a central issue in their campaign speeches. The federal elections that fall became a referendum on the 14th Amendment and the legitimacy of the Rump Republican Congress. In speech after speech, President Johnson and the Democrats declared that the Rump Republican Congress was an illegal assembly and that it was unconstitutional to propose an amendment while Southern state representatives remained illegally excluded from Congress. Johnson and the Democrats hoped that their party would win enough seats that fall to enable them to set up a second Congress, one that they would insist was the true Congress. For example, Democrat Montgomery Blair, Postmaster General under Lincoln and a member of one of the most influential families in the United States at that time, insisted in his speeches that Democrats had a patriotic duty to resist the illegal Republican Congress. Blair declared, and here I quote, "The Democratic Party must save the country from a new rebellion and civil war. The war that is to come will not be in the South, but in the North. The Republicans in Congress hold power only by excluding Southern states, states which they themselves recognized as in the Union when they counted their votes for purposes of the 13th Amendment. But these Republicans now mean to keep these states out and govern the whole country by the minority in Congress. But in the next Congress, Northern Democrats with the Southern states will have a majority. And then you will have two presidents, two Congresses, one recognized by the radicals, the others recognized by the Constitution." Blair's speech was republished in newspapers around the country. Other Democrats picked up on the idea and repeated it throughout that summer and fall, including President Johnson, as he rode the circuit supporting Democratic candidates. Republicans responded with their own speeches warning of a second civil war. Republican Senator Henry Wilson of Massachusetts spoke to a crowd in Indiana, quote, "We are told by the president, even in his speech on his way home, that we may have civil war." Montgomery Blair went into Maine this autumn and told the people of that state that we were plunging into civil war, that we might have two Congresses. Democrats, in fact, intend this, if they have the power. It is what the president means when he talks about the Republican Congress being a body of men unconstitutional and unlawful. If the Democrats can get a majority in Congress made up of rebels, unrepentant, unpardoned rebels, and their sympathizers here in the North who are willing to act with them, they intend to make a Congress of these people and rule out the legitimate Congress of the United States and then maintain their authority with the Army of the United States. End quote. Wilson's last point about the Army of the United States supporting the Democrats was not an exaggeration. As President Johnson rode the circuit giving speeches that summer and fall, he was accompanied by no less a figure than Ulysses S Grant, commander of the Union Army. Grant sat silently on the stage right next to the president as Johnson called for a rejection of the Republican Congress. Grant never said a word, but the point of his presence was obvious. President Johnson wanted everyone to understand that should a second Civil War come, the Union Army of the North and the Confederate Army of the South would both be on his side. Both Democrats and Republicans, in fact, began to discuss available military options if Democrats secured a few, just a few, additional seats in Congress that fall. It would be one of the most important elections in the history of the United States. In the end, it was a deadly riot in the city of New Orleans that turned the tide in favor of the Republicans. That July, mobs at the direction of the mayor of New Orleans attacked an assembly of freedmen meeting in convention to discuss the issue of black suffrage. Dozens of freedmen were killed, many of them veterans of the Civil War. The attack became a national scandal. Republicans pointed to the massacre as a prime example as to why we needed an amendment protecting the rights of all citizens to free speech and free assembly. President Johnson's response to the riots became a public relations disaster. Before the riots, Johnson had assured local officials that federal troops would not intervene to protect the freedmen, and after the riots, Johnson encouraged local officials to continue to suppress what he called illegal assemblies. Worst of all, from a political standpoint, Johnson blamed the violence on the congressional Republicans and their support for the rights of freedmen. When Johnson tried to assure the country that state officials could be trusted to protect the enumerated rights of American citizens, Republicans simply pointed to the state-directed violence of New Orleans. And in the end, those riots became a symbol of why the country needed to elect Republicans that fall and ensure the adoption of an amendment that would protect the privileges and immunities of all American citizens. In the end, Republicans won a landslide victory that fall. And in doing so, they secured a popular mandate to ensure the ratification of the 14th Amendment. And so it was that just then, in the seeming moment of victory, that we almost lost the 14th Amendment. You see, ratification had not been going well. When the Republicans took their seats for the second session of the 39th Congress, every former rebel state, except Tennessee, had rejected the 14th Amendment, and it now appeared impossible to get the 3/4 of the states to ratify as required by Article 5 of the Constitution. Congress was faced with a difficult choice of either ratifying the 14th Amendment by counting only the votes of the northern states, or somehow convincing the southern states to change their minds. Counting only northern votes would create a political firestorm, especially since southern state votes had already been counted for the purposes of the 13th Amendment. On the other hand, it appeared impossible to change the minds of white Southerners. Another option, of course, was simply to give up on the proposed amendment and proceed by statute. Radical Republicans had long insisted that no amendment was necessary and that Congress should be viewed as having unlimited power to pass civil rights laws. Now that the election of the fall had returned Republicans to Congress in even greater numbers, radical Republicans called for abandoning the 14th Amendment and simply imposing their will on the South by mandate, by statute. Thaddeus Stevens introduced legislation giving Congress power to control all the municipal laws of the southern states, even after their readmission to Congress. If Stevens succeeded, the ratification of the 14th Amendment would be irrelevant and likely ignored. And it was at this point that the Ohioan John Bingham, author of Section 1 of the 14th Amendment, stepped in and saved the amendment. On January 16th, 1867, Bingham took to the floor of the House and, in the words of the New York Times, delivered, quote, "one of the most eloquent and effective speeches ever heard in the present Congress," end quote. In his speech, Bingham reminded his colleagues that constitutional change requires a vote of the people, not a vote of Congress. Bingham denounced Stevens' bill as, quote, "a substantial denial of the right of the great people who have saved this republic by arms to save it by fundamental law. Law emanating from the people. Law resting upon the sovereign will of the people and the people alone. Law beyond the power of this Congress or of any subsequent Congress by mere legislative enactments to repeal or in any manner limit or restrict. Let the future safety of this republic rest upon guarantees embedded in the Constitution, embedded there by the sovereign act of the people, and not upon the repealable acts of Congress. I submit with all confidence that what is contemplated by this gentleman's bill is to patch up a restoration by the usurpation of powers which do not belong to the Congress of the United States, to induce the people to fling aside the constitutional amendment and thereby subject the future of this republic to all the dread calamities which have darkened its recent past." In the end, Bingham prevailed. He convinced his colleagues to continue their efforts to use the amendment process rather than abandoning federalism and the principle of limited national power. When Thaddeus Stevens realized his bill would fail, he was furious, and he denounced Bingham on the floor of the House, as only Stevens could. In words colorfully recorded in the Congressional Globe, Stevens declared, quote, "in all this contest about Reconstruction, I do not propose to take Mr. Bingham's counsel, recognize his authority, or believe a word he says," end quote. There was good reason for Stevens' frustration. Ratification was not going well, and Thaddeus Stevens was running out of time. He was dying. At that moment, he had but a few months to live. When Stevens spoke in the House, he did so in a voice so low and weak that members had to leave their seats, and they did so and gathered around his chair in order to hear what he was saying. It was altogether possible that Thaddeus Stevens would not live to see ratification or know whether all his efforts to secure freedom in the South had been a complete waste of time. For his part, Bingham was optimistic. With their strengthened congressional majority, Republicans passed the first and second Reconstruction Acts, and these acts directed the military to supervise the creation of new governments in the South, governments that would be elected with black votes and which would conduct a second round of voting on the 14th Amendment. Guiding that military effort would be Secretary of War Edwin Stanton, a reliable Republican that Congress trusted to get the job done. President Andrew Johnson also knew that Stanton would get the job done, so he kicked him out. In the summer of 1867, President Johnson replaced Stanton with Ulysses S. Grant, the man who had accompanied Johnson in his ride around the circuit in 1866. Removing Stanton would trigger the impeachment of Andrew Johnson and bring on the third and final act of the drama of the 14th Amendment, and so Act 3. When President Johnson removed Stanton, he had not yet violated the Tenure in Office Act. Instead, Stanton's removal triggered the procedures of the act, and because the removal took place while Congress was in recess, Grant could serve on an interim basis until the next session of Congress. At that time, Congress would decide whether to approve the removal or insist that Stanton be returned to his office. The next session of Congress was still months away, so when Stanton heard of his removal, he obediently turned over the keys of his office to Ulysses S. Grant. And from that moment until Congress returned, ratification of the 14th Amendment ground to a complete halt. From August 1867 to January 1868, not a single vote was taken on ratifying the 14th Amendment. Well, there was one vote if you count Ohio. Ohio rescinded its previous ratification and voted to reject the 14th Amendment. At this point, it was obvious that without new votes in a reconstructed South, the 14th Amendment would die. But getting new votes in the South required the vigorous hand of someone like Edwin Stanton and not the cryptic silence of Ulysses S. Grant. When Congress returned that winter, one of their first acts was to consider whether to disapprove the removal of Edwin Stanton and demand that Grant give back the keys to the office of Secretary of War. While awaiting Congress's decision, President Johnson instructed Grant to do nothing without first consulting him. Johnson likely planned to challenge the Tenure in Office Act in court and tie up the issue in litigation for months, maybe years. And during that time, momentum for the 14th Amendment would disappear. On January 15, 1868, Congress voted to disapprove of Johnson's removal of Stanton, and at that moment, the fate of the 14th Amendment lay in the hands of the man who had won the battles of the Civil War, Ulysses S. Grant. Grant had to choose between the demands of his commander-in-chief and the desires of the Republican Congress. Grant chose Congress. For reasons that remain unexplained and obscure to this day, when Grant received news of Congress's vote, he did not go to the president as instructed, but instead he went to Stanton, and he gave him back the keys to his office. Grant then wrote a polite letter to Johnson resigning his position. Stanton, for his part, grabbed the keys and promptly barricaded himself in his office, and he refused to leave. And to say that President Johnson was furious would be an understatement. Betrayed by General Grant, Johnson announced that Stanton was fired and would be immediately replaced. And that announcement expressly violated the Tenure in Office Act, and the House of Representatives immediately voted to impeach the President of the United States. House member Thaddeus Stevens insisted on carrying the articles of impeachment to the Senate himself. Stevens was too weak to walk on his own. So a second man was chosen to assist him, his old adversary, John Bingham. And so it came to pass that these former antagonists, the 14th Amendment author John Bingham and the dying Thaddeus Stevens, together entered the chamber of the Senate carrying the articles of impeachment, with Stevens holding tightly to the arm of the man who he once claimed he could never trust. President Johnson would escape conviction and removal by a single vote. Politically, however, he was defeated. Henceforth, President Johnson no longer would obstruct the Reconstruction Acts or the effort to ratify the 14th Amendment. And with Johnson and his administration no longer blocking the way, The Southern states proceeded to draft new state constitutions, elect new governments, and hold new votes on the 14th Amendment, this time with the participation of enfranchised blacks. One by one, the Southern states changed their prior votes, and they ratified the 14th Amendment. And on July 14, 1868, Alabama became the 28th state to ratify, meeting Article 5's requirement of 3/4 of the then 37 states. On July 20th, Secretary of State William Seward issued a provisional proclamation, and on July 21st, Congress made it official and announced that the people had added a new amendment to their Constitution. Southern states again sent representatives to Washington, and this time they were readmitted, and they were allowed to return to the seats that had been empty since the start of the Civil War. It had been two of the most dramatic years in the nation's constitutional history, second only to the Civil War itself. Excluding the Democrats in order to ensure the passage and ratification of the amendment had almost triggered a violent insurrection. On multiple occasions, the effort had seemed impossible. It required undying commitment by men like John Bingham and an act of insubordination by America's most famous general to get the job done. In short, we almost did not experience a new birth of freedom. But perhaps it is this very realization that makes the celebration all the more sweet. And not just because there was victory, but because despite the constant temptation by all parties to throw out the constraints of constitutional government, in the end, the participants followed the procedures of the Constitution and they let the people decide for themselves whether to change their fundamental law. As Lincoln had remarked about the 13th Amendment, the success of the 14th was also both fundamental and astounding. Defeating the lesser angels of our nature, we brought forth a new birth of liberty for that generation and for all the generations that followed. It's a great story and one worth celebrating, and I thank you for giving me the chance to tell it. Thank you.
We have time for questions.
I understand. Oh, I think I'm supposed to take it. I understand this is a chance, and I very much welcome the chance to take questions from guests, from faculty, from students, anyone, please.
I'm uniquely interested in the question of whether or not the states seceded. You know, were they still considered part of the Union? And to your point earlier about the 13th Amendment, the Southern states were counted for votes for ratification, but then their elected members were excluded from Congress.
Indeed.
I guess I'm interested in your reaction to sort of an ends justifies the means kind of analysis, or what your take on that would be. Should they have been admitted? What might have been the options if they had been admitted in order to achieve what the Republicans wanted? Kind of a broad question.
My first response is it was astounding what they did. I'll just go with the language of Abraham Lincoln. If they had been readmitted, if the Southern states had actually been readmitted, that would have been the end of any efforts to secure civil rights in the South. The Democrats would have had overwhelming numbers in both the House and the Senate, and of course they would have had a president completely on their side. And Andrew Johnson was committed to a restoration of business as usual as quickly as possible to heal a nation that was still, utterly devastated, both North and South, by the Civil War. So there was a small opportunity, just a small period of time when a window was open to secure the rights of the South and also to prevent the North, the Union, which had spent so much treasure and precious blood in securing the victory of the 14th Amendment, to secure freedom and secure the principles of the North, which had guided their actions in the Civil War all along. And that meant that they had to prevent the former rebels from taking over the government of the North. So there are two things they had to do, neither of which would have been possible if they had readmitted the Southern states. One was to ensure that they had diminished representation in Congress unless they enfranchised the blacks and got a new reliable population of supporters of the Republican Party in the South. And secondly, securing the rights of the freedmen, freedmen who were going to become citizens due to the first sentence of the 14th Amendment, and who then would be protected in their privileges and immunities, due process rights, and equal protection of the laws, and that would protect them against the black codes, which of course had emerged in the aftermath of the 13th Amendment. So they had to be excluded, but that leads to the first part of your question. How do you exclude states that weren't gone? The whole theory of the Union effort was to reject the idea of secession. It's impossible for any state to leave the Union. They didn't have one single theory as to what had happened, which doesn't surprise me because this was wholly unexpected as an event in American constitutional history. But the theory of the Union had been primarily something along the lines of bad guys had taken over the buildings in the South. There was no secession. The Constitution doesn't allow secession, but a criminal gang had taken over and excluded the legitimate governments of the South. And so we're fighting a war to rescue the people who have been taken hostage in the South by this criminal gang. Well, if that's your theory, so they reject secession, they reject the Calhounian states' rights theory that the South used to justify secession. But if that is the theory, justifying a military incursion into the South, we have to do this. Our people are there, and they are still in the Union, and we have a duty to protect them. Then once the war is over, how do you deny the restoration of those states which are always in the Union? And it became a subject of ongoing conversation, debate, and just enthusiastic criticism in the newspapers, both North and South, and it never received any type of coherent theoretical answer by the Republican Party. Different sections of the Republican Party had different theories about it, where there was radical Republicans who believed that the southern states had committed suicide through their actions to the Civil War, the moderate Republicans who believed that the states were still in the Union, they still remained as states, but we needed to make sure that the criminal gangs didn't try to represent them when they came back into Congress. So there were multiple theories, but it was a terribly difficult theoretical issue, which had an enormous implications for the politics of the day. It was because the Republicans didn't have a coherent theory of what they were doing, which opened the door to President Johnson to plausibly maintain that the actions that were being taken by the rump Republican Congress were illegal and unconstitutional. It simply remained a political issue that went back and forth with no constitutionally satisfactory answer available to this day. Historians still debate the theory of secession and the exclusion of the southern states. Yes, please.
My question is two-point. In Stanton's biography, it talks about when he locked himself in his office.
When he barricaded himself in his office.
Right. They brought him food, he slept. You know, I'd like to know how long you think that was. My second part of my question was, his job he always wanted was to be on the Supreme Court, which Grant appointed him to just before he died. Did President Johnson ever think about appointing him to the Supreme Court so it wouldn't have that political conflict with him?
That's a great question, and one I don't know. I really don't know. I appreciate your insight into what happened at the time. He really did when I said he barricaded himself in his office, I wasn't using a metaphor. He literally barricaded himself in his office, put furniture against the door so he couldn't be removed, because he was trying to create facts on the ground. I am here. It forced the president to try and do something rash to remove him, and that would trigger the president's impeachment. How long he was in there, once again, I'm not sure. I know that he was in there for some time, enough so that they not only delivered him food, but all the dignitaries of Washington. There was a parade of all the Republican dignitaries during the day to go and visit Stanton, barricaded in his office, because of course they were trying to play this up as a political issue. But impeachment happened very quickly. And I think once the articles of impeachment were voted on in the House, and then it went to the grand impeachment trial in the Senate, at that point I don't think he had any interest in forcibly removing him and putting in Lorenzo Thomas, I think, was the person he was going to replace Stanton with. I think at that point it was safe for Stanton to come and go until the actual impeachment and removal vote was taken in the Senate, and that was going to take a couple of months.
So Johnson never thought about putting him on the Supreme Court?
Not that I know of. Not that I know of.
But 2 months he appointed him, Grant did, and then he died.
Yeah, I wouldn't. Andrew Johnson was a bullheaded man of a president, and that would have been a rather canny political move for a president that isn't known for making canny political moves. But I don't know. I don't know whether or not he ever considered that. Please.
I've got the microphone, so you got a call on me.
Okay, there you go. Whoever has the microphone, presumptive legitimacy.
First of all, thank you. Absolutely wonderful presentation for us. Just remarkable. Ron Cherno's recent book on Grant and White's book, American Ulysses, has shocked a generation of us who thought Grant was a scoundrel, and I think restored his reputation. It was very interesting that Grant did what he did here. Could you just shed more light and color on that part that Grant played? It seems like his role in the country was so popular that maybe he influenced that more than we would have thought.
Well, his popularity was in question as far as the Republicans were concerned. Certainly he was deeply suspect on the part of radical Republicans because he was silent. He wouldn't take any position during those very dramatic months of the election of 1866. He accompanied Johnson, and that was a very dramatic move to actually sit there showing the support of the Union Army, but he never spoke at any of those events. Because he was giving a visible display of support to President Johnson, Republicans began to suspect whether or not he was really on their side. And then once he's chosen by Johnson to serve as interim Secretary of War after the removal of Stanton, then now it became a question as to whether or not he was going to go full board over into supporting the Democrats. But once again, he remained cryptically silent, and newspapers throughout all those months talk about the silence of General Grant, and everyone wondering whose side he's ultimately going to be on. His biographers attribute his silence and his ultimate move to deliver the keys to Stanton on his growing ambitions to be president of the United States. And that he saw the direction the wind was blowing. He decided that he would have better chances with the Republican Party than the Democrats, and so he became a moderate Republican, a nominal Republican. I see no evidence of that in what I've read. I think he actually was going through a very difficult decision-making process, and probably was influenced by accompanying Johnson. He may have started being a full supporter of Johnson, because Johnson in many ways was continuing the policies of Abraham Lincoln. Abraham Lincoln, with his 10% plan and his opposition to the Wade Davis plan, showed himself to be very willing to have an immediate restoration of the South, far more quickly than radical Republicans wanted. And so when Andrew Johnson also wanted to have an immediate restoration of the South, there was nothing about that was contrary to anything that President Lincoln had done before he was assassinated. So I could see Ulysses S. Grant saying, "This is still my commander-in-chief. He's still doing the things that my former commander-in-chief had suggested were appropriate." So he had no reason to be against President Johnson, and maybe a lot of reason to be suspicious about these fire-breathing radicals in Congress. But accompanying Johnson, who was simply a problematic character on a number of grounds, may have convinced Grant in the end that Johnson was in fact betraying the victory of the Civil War, and he may have had a crisis of conscience that led him to defy his own commander-in-chief for principled reasons and give those keys to Stanton. But I was surprised by the biographers, because I also read the recent biography of Grant, that they don't make much of this event. When you read the newspaper, I encountered this event through my research in the newspapers at the time, and the events which triggered the impeachment of Andrew Johnson. This was explosive. If you think Watergate, right, and some of us do think, some of us remember Watergate was explosive, or the presidency of Bill Clinton, or when Trump fires Mueller, or whatever the heck is going to go on, it's nothing compared to the drama that splashed across the nation's newspapers when President Johnson fired Stanton, and Stanton then barricades himself. Can you imagine this? The president tries to fire him. He barricades, a member of the executive branch, barricades himself in the office, and Congress goes back and forth supporting his efforts. It was a drama, and everyone was waiting for Grant. And then Grant delivers the keys, and newspapers, the New York Herald, the New York Times, the Chicago Tribune, give hour-by-hour updates on what Grant is doing, the supposed efforts by Grant to try and visit President Johnson. Oh, but Johnson was in a reception at the moment. And so Grant was unable to see the president. So he decides not to see the president and simply give the keys to Stanton. And these are headlines after headlines after headlines in the newspapers at the time. Everybody was aware that the event was being controlled by Grant, the leader of the Union Army. It was just an amazing event that I was surprised to see didn't get more play in Grant's biography. I think it makes Grant a far more important figure in the passage of the 14th Amendment and a far more interesting character, just like you've suggested, than we've grown up believing. Seeing him as he was a great general but a terrible politician with a corrupt administration. I think there's much more to Grant. And I got that through my research for this book. Yes, please.
How do you be so certain as to what might have happened without the passage of the 14th? I mean, some people look at the Civil War as simply northern industrial might making its way to center stage, and might not some of that have carried over even without the 14th Amendment and different ways of resolving this southern representation?
Well, I think it's quite, politics is going to find its way. It's like water. It finds the path of least resistance, and even without the 14th Amendment, politics was still going to play a role. Industrialization was still going to play a role. Expansion west was still going to play a role, and all of those were going to have an impact on the development of law after that. But the outcome that we did get was an outcome that didn't involve a statute, which would have been subject to repeal by later Democratic administrations. And I think there's very strong evidence that they would have immediately repealed. Well, I know they would have immediately repealed the Civil Rights Act of 1866. They announced it. It was part of their party platform at the time. So you would have seen statutes going back and forth, but you wouldn't have had the entrenched provisions of the 14th Amendment that then would become the subject of Supreme Court attention and Supreme Court enforcement as you move into the 20th century. And so maybe, and I concede this, I'm not exactly sure, how the politics would have played out had we not received a 14th Amendment. But I do feel fairly comfortable it would have removed an incredibly important tool of judicial review and judicial protection of individual freedom once we moved into the 20th century. And we all know the history, right, of the 13th, 14th, and 15th Amendment. They weren't immediately enforced. Reconstruction ends, you have the removal of the federal troops there in the 1880s. Provisions like the Black Codes are not enforced against are not struck down by the Supreme Court. You move into the Jim Crow era. You have a lot of tragedy in terms of the hopes of these Reconstruction amendments, particularly the 15th Amendment, and the hope in giving black males the right to vote. This was going to give the freedmen in the South political power so that they could prevent things like the Black Codes and Jim Crow laws from being developed. None of that came to pass as the country moved on to other matters, maybe due to the Industrial Revolution and the Progressive Era. But nevertheless, they left something, even if it wasn't vindicated at that time, even if it didn't have an immediate impact on politics at that time. I think those amendments became critically important in giving leverage and textual hooks of justifying the actions of the Supreme Court in the 20th century. It is speculation, but I remain glad that they're there. Yes, please.
Section 1 of the 14th begins talking about citizenship.
Yes.
The definitions by state and federal, and ends with the application to persons rather than citizens. What was the logic there of making that switch?
The idea that there was a distinction between the rights of citizenship and the natural rights of all persons was a fundamental theory of Republican abolitionist theory, and then ultimately moderate Republican theory as you move into the Reconstruction phase. The idea was that there were certain things that came along with the idea of citizenship. There were certain privileges and immunities that were only given to citizens, right? And this, ultimately that would include suffrage and other matters as well. But even if one wasn't a citizen, even if you were merely a stranger in the land, visiting here for a certain amount of time, there nevertheless were certain natural rights that all persons should enjoy, regardless of citizenship. And these would be the right not to have one's life, liberty, or property deprived from you without due process of law, and the right to equal protection of one's right to life, liberty, and property. So it was a distinction based upon ideas of natural law. And it wasn't something that emerged at the very end, by the way. You can find this distinction in the speeches of John Bingham in 1859. The speeches against the admission of Oregon, when Oregon was becoming a state. But it was fairly widely shared by other Republicans as well. What it does mean is that you get Section 1 of the 14th Amendment, and this is something that isn't generally recognized. It sets up Section 1 that creates two categories of rights. You have privileges or immunities of citizens. What are those? And how are they different from the due process rights and equal protection rights of all persons? Section 1 used two different kinds of language. The Supreme Court has never developed the distinction. Soon after the passage of the 14th Amendment, the Supreme Court hands down decisions like the slaughterhouse cases, and then in my mind, even more importantly, the Cruikshank case about a decade later, that dramatically reduce the enforcement power and the rights provisions of the Privileges or Immunities Clause, and it basically becomes a lost provision in the 14th Amendment. And it isn't until the end of the 19th century into the 20th century that the Supreme Court begins to develop the Due Process Clause. And over time, the Due Process Clause of the 14th Amendment has become the most provision, the most important provision in the Supreme Court's enforcement of the 14th Amendment. And within the Due Process Clause, the court protects the rights of citizens, the rights of all persons. It's just one grand list of rights without any distinction that would have been made by the text of the 14th Amendment at all. And there are debates to this day whether or not the Due Process Clause should be viewed as incorporating the Bill of Rights against the states, whether or not it should be viewed as transforming the Second Amendment into a provision protecting the individual right to self-defense or the right to bear arms. There are a lot of questions over the court's analysis of the Due Process Clause, and most scholars believe that the court has gotten it absolutely wrong. There was never an idea that the Due Process Clause represented the rights of citizens to some degree, or the substantive rights of all persons to some degree, and maybe a few other procedural rights. Most scholars believe that they got off track somewhere along the way, and that we should revisit that textual distinction that was placed in the Constitution from the very beginning. One would suggest there's something called privileges or immunities of citizens, which only citizens get, and other rights called due process rights and equal protection rights that belong to all persons. Some of us are on a quest. We have a vision that someday the Supreme Court will do this. Someday the Supreme Court will revisit the Privileges or Immunities Clause, but they've shown no interest to date.
I think we have time for one more question.
One more? You call. I'm not going to be responsible for the last question. You'll be responsible for the last
Somebody other than me, Jason.
The gentleman over there in the white shirt?
There we go.
That was for Joe. My question is about the application of the 14th Amendment to citizenship.
Okay.
And now the Congress has never spoken on who's a citizen who's born in this country. And so we see the evolution of the 14th Amendment over all these decades since it was passed. So I'm wondering if you could speak to who the 14th Amendment was supposed to apply to as far as citizens, and if you think it's off track, how it's applied today.
Right. So what is the scope? What do the documents indicate? The Citizenship Clause of the 14th Amendment, all persons born or naturalized in the United States or citizens of the United States or of the state and of the state wherein they reside. The Citizenship Clause was the last provision added to the 14th Amendment. It came very late in the game. And the provision that was added echoed almost the exact same language which had been included earlier in the Civil Rights Act of 1866. So Congress had initially in passing that Civil Rights Act in the early months of 1866, declared that all persons born are going to be citizens of the United States. That's going to establish that the freedmen in the South are going to be citizens. And here are the rights of citizenship, and the Civil Rights Act provides equal protection to rights to own property, the rights to sue, the right to testify, things along those lines. There's a question as to whether or not Congress had power to pass, to establish the rights of citizenship. And so in order to ensure that the Civil Rights Act and that aspect of the Civil Rights Act wasn't struck down, they added that clause to the 14th Amendment. Once the 14th Amendment was ratified, they then repassed the Civil Rights Act of 1866 just to ensure its constitutionality. Now, so that's how it got there, but what's its meaning? It talks about persons born, that was clearly meant to protect the freedmen, born or naturalized. But it also talked about, and subject to the jurisdiction of the United States, right? What does it mean to be a person's born in the United States and subject to their jurisdiction? And then you get into the modern debate over who should be subject to that automatic grant of birthright citizenship. I haven't seen enough in the records to allow me to make any kind of conclusion as a matter of those debates, because the focus of their attention simply wasn't on that. There were people who wanted to make sure that the rights of citizenship didn't automatically attach to Native Americans. So they knew that subject to their jurisdiction was going to exclude the particular treaty relationship that we had with the Native American tribes at the time. So I'm comfortable with that idea. The representatives from California said, we need to be careful because we have a population here from across the Pacific Ocean, and we don't want them also becoming citizens, do we? And their voice just echoes into silence, and it isn't picked up. So they were aware of the potential broad application of the Citizenship Clause, but it simply wasn't a subject that had their major attention at the time. And so it's going to be up to the court and up to politics to try and argue this out as a matter of modern conception. But I haven't seen anything in the historical record that lets me just announce, here's what they were thinking when they passed it.
Please join me in thanking Professor Lash.